Hello, IP friends. Welcome to #IP series with your favorite podcast host, Rita, and we're reaching the. Now, if you're a first-time listener, I just want to say welcome to my podcast. I hope you find my podcast interesting. I hope you learn something, and I hope you are kind enough. I would appreciate if you guys share my podcast, especially if you learn something. I mean, there's love in sharing, and again, you wouldn't miss out on any juicy episode if you subscribe and also favorite my podcast on any of the listening platform you are opportune to listen to #IP series, be it Anchor, Spotify, Apple, Google, Spreaker, you name it. Now, for my returning listeners, guys, I just want to say I love you and I appreciate you guys. You guys are fab. I mean, thank you for always coming through for me, for listening, for sharing, for liking, for favoriting, and also, spreading the good news about intellectual property, which is what we do here. We talk about recent trends and development on copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication. Now, speaking of geographical indication, a few weeks back, we had a national conference on geographical indication in Nigeria. Privileged to have been part of the technical working group that worked on the draft geographical indication law. So basically, geographical indication refers to products originating from specific geographical origin and possesses qualities or a reputation that are attributable to that location. And during the conference, we saw some agricultural and non-agricultural products on display, like the Yari fish, which was like one of the biggest fish I've ever seen. Then we had the Then we had the dogfish again from Kebbi, shea butter, and then sesame seeds, the Nsuka yellow pepper. I had to get one for myself and my family. Ginger, there was a ginger balm as well. I don't know how many of you know aboniki, but this is way better than aboniki balm. This was made from ginger specifically. So guys, we have a lot in Nigeria that we can commercialize. But yeah, that's my IP news for today. I'm just gonna get into today's episode, and I hope you guys enjoy. But yeah, I do have some sort of publication coming out. Just my own highlights from the conference itself. So yeah, welcome to today's episode, guys. So today's case is a very interesting one, which I think would benefit startups, SMEs, MSMEs, and every business person out there. So I think one of the issues we have in Nigeria with regards to IP when you're talking about trademarking, be it a name or logo, is the fact that we are sometimes not original. We tend to be inspired, and then we don't know when we are crossing the line with our inspiration. So it's like, oh, you've seen something similar out there, and then subconsciously, when you want to create your own brand around that, and that becomes like your reference. So there was this conversation going on Twitter, and I got tagged on the post by @Kinsmain and @Peter Payne. So it's spelled Peter and Parney. Kinsman is Kinsmane, and he tagged me. They both tagged me, and I was like, okay, I've seen this conversation somewhere, and then I had to make a promise I was going to do a Twitter series just to lend my voice, not with regards to the case, but just to shed light on certain areas of this type of IP, which the case is focused on trademark in this instance. And I did the Twitter, version. So here's the podcast version. Not promising any newsletter, guys, so bear with me. No newsletter for this particular case, but um if you like to, do some sort of consultation, I'm always open to your emails, which you can send to at ipseriesinfo@gmail.com. Sometime in November 2021, Coca-Cola, which happens to be an American multinational beverage corporation with a franchise in Nigeria and one of the foremost fizzy drinks company in the world, sued Mamuda Beverages Nigeria, who is the manufacturer and owner of Pop Cola drink, a very, very, very popular fizzy drink in Kano State, Nigeria. Um, over trademark infringement of the use of the word pop in scripts that is identical, and also the use of their trademark ribbon device, and they were asking the court to restrain them from distributing and advertising their pop cola products because it would cause confusion amongst their consumers. As an intellectual property, your name, the name of your brand, the logo, sign, symbol, word, numbers, could be used to distinguish your mark from another person's own. And one of the elements that you must provide, in line with Section 10 of the Nigerian Trademark Act, is that your mark must be distinctive in nature. And that means it must be very unique, that if you put Mark 1 and Mark 2 side by side, no one will confuse one for the other. Like, you'll see what makes Mark A different from Mark B or Mark C or Mark D, as the case may be. Now, the requirement or element of a trademark, or what is really expected of a trademark owner, is that the person who has the mark that is registered or not yet registered or unregistered, let's just say unregistered, must consistently have used that mark for commercial purpose. That means within the last 5 years you have been consistently using the mark, and in this case Coca-Cola has been doing that since 1953. Let's do the math. This is 20 let's do the math, guys. This is 2022 minus 1953. That's 69 years they've been using the Coca-Cola ribbon design or device rather for 69 years. I'm sure we have relatives, uncle, fathers, mothers that are 69 years, so you can imagine someone being in business that long. But then how has this person managed to consistently commercialize this mark? Simple answer: by having a good trademark and IP strategy. Now Coca-Cola is a subsidiary of AG Leventis Group, which commenced business in Nigeria in 1951 with a franchise to bottle and sell products of the Coca-Cola company in Nigeria. So you will find that the Nigerian Bottling Company is a subsidiary incorporated under AG Leventis Group. Now, a trademark can be registered as a device mark, a word mark, a sound mark, a three-dimensional trademark, a color mark. Now, a device mark could be in form of a sticker, a logo, a label, a styled wording, a graphic image or design, which may or may not have words attached to it. Same thing for word mark. Word mark could be a combination of word, letters, or numbers. Sound mark, that's one of the marks that I feel is very difficult to trademark, because you must show that the sound in question is very unique. For instance, last year a company tried to trademark the sound of fizzy drink when you open it, and the European copyright. The European intellectual property office refused to grant them a a trademark for that sound, saying that it was not unique enough. But then, if you, I always like to refer to these guys. Okay, so if you are a fan of Pittsburgh, I'm sure you heard. "Ee-hoo!" So his Grito yell was trademarked during the pandemic for entertainment services. So sometimes you hear this Grito yell sound, hoping to find Pitbull being featured on the song, but nay, guys, nay. He just licensed that sound out. So as a trademark owner, you can commercialize your mark by licensing it, by creating a franchise, by leasing it, by don't sell, please, guys, unless it's very important, but please don't. But that's another conversation for another day. Then you have a three-dimensional mark. You have the color marks such as the Tiffany blue. If you love accessories, I'm a fan of the wedding sector. So engagement rings, wedding rings, wedding dresses, everything. I love it. Then Cadbury purple, you have the DHL yellow, so, and a host of other colors that have proven over the years to be distinctive in color. So in order for you to own a trademark, you must pick out of the 45 classes under the NICE classification. So we have what is called the NICE classification, where you get to pick which class can be linked to your product. So you have, it's divided into goods and services. So if you're rendering services, look through this. If you have products for sale, look at the classification and pick which one that applies to you both. Now, the term of duration for a registered trademark is 7 years, which is also subject to renewal for another 7 years and another 7 years, making it 14 years. And but with a good IP portfolio, a good trademark portfolio, a good trademark strategy, you can, keep extending your protection. So for instance, just do a Google search and you just check out brands that have been in existence since the 80s, 1800s, the early 90s, late 90s, and the rest of them. You can also do that by carrying out your own trademark due diligence by doing a search at the trademark office. If it's in Nigeria, or any other country that you wish to expand your product or your services to, because trademark or IP, intellectual property, is territorial in nature, and it's only the countries that you register your IPs that you get to enjoy legal backing and protection, total protection of the law on your side. Anything outside that, you're on your own. Next is to consider the types of trademark to use and register in order to enjoy all of this benefit that comes with it. You can also check out one of my episodes where I talked about the NICE classification and also public domain, and also when the AFCFTA agreement came into force January 1st 2021. So you can check out one of the earliest podcasts I made last year to know more about the NICE classification. So when you want to do a trademark, or when you're trying to pick out a trademark, don't go for a descriptive name or logo, something that tells what your product is about or what business you're going to do. That means it's too descriptive. For instance, you can use white for white paper. Then avoid generic words or terms. Um, Basically, any word that has been considered to be very common. For instance, now aspirin is considered to be a word for tablets for headaches or body pain, um, and several others. So if you decide to use any of these kind of marks, it doesn't give you so much protection as an IP owner. You just have like a limited or no protection at all. So best go for a fanciful or coinful word, um, which is like the most preferred form of mark, because it shows that you put a lot of thoughts and efforts into coming up with that name, that logo, that sign, that symbol. You know, it's not existing anywhere. So when someone hears the name of your brand, you're like, this is new, haven't heard it, never heard of it, don't know what it means. Fantastic. That's what we want when people hear your trademark. Now you can use an arbitrary mark that does not have any relation to your product or service. For instance, orange, you know, orange is a fruit, but orange is a pharmaceutical company in Nigeria as well. Same thing for Apple Inc. Apple is a fruit, but it's a name of a telecom um company that we all know of. Then suggestive words that tells your consumer what your product is about. Pink ice cream, we know it's ice cream, it's gonna be pink, you know, that kind of thing. We need you to stay away from that. So best form of marks, go for a fanciful or coinful mark or an arbitrary mark. Maybe a suggestive mark, but stay the hell away from a a descriptive mark or a generic mark while wanting to, if you're considering trademarking a name, a logo, a sign, symbol, numerals, color, smell for your business. So one thing that stood out for me and also kind of motivated me to do a series to talk about this case was because I read the post by Kevin Odans, who goes by Mr. Odans, that's Mr. and Odanz. He made a publication on the 19th of February, and when I went through the comments after I was tagged, I saw that a lot of people were confusing infringement and plagiarism. So I wanted to shed light on the difference between plagiarism and infringement as it applies to intellectual property. Because one of the comments said, I detest plagiarism with passion. And Mr. Kelvin Odans, responded saying, if you've ever been a victim of plagiarism, you did hate it with passion. So what is plagiarism? Now, plagiarism applies to the attribution or use of someone's work without acknowledgement. I think one similarity between plagiarism and infringement is that there's no acknowledgement in either of these cases. However, for plagiarism, this person is trying to pass off your creative work as their own, and this is related to or very common in the academic space and has some sort of creative elements which falls under copyright, aka literary theft, and can be considered to not be intentional. So the act itself is not intentional, whereas for infringement is like you have not been authorized to use, you've not been authorized, you've not gotten any consent or permission to use an intellectual property rights holder exclusive rights such as copyright, trademark, patent, industrial design, geographical indication of land. So you don't have the permission of the rights holder to commercialize or exploit their work. So it was more or less very intentional, like, okay, yeah, I'm going to use it because Nigerian IP laws are not good, or because no one's going to say anything, or who cares, no one is really going to do anything. Like, your intention is basically to deceive the public. Like, so I want to sell, let's say, Omo detergent, and I create Omo detergent. Now, I'm doing that to divert profit from you, because last, why is Omo detergent making more money and having more customer? Why don't I come up with Omo and make it 5 naira so people will have more customers buy into it? So other than diverting profits, you are also deceiving the public, making them think that Omo and Omo are basically the same thing. So I hope that is clear. I've clarified the issue as to plagiarism and infringement. This is not this case between Coca-Cola and Pop-Cola is not a plagiarism case. It is an infringement case, still in court, and the court has some decisions or ruling to make as to whether or not Pop-Cola really infringed on Coca-Cola's trademark, and the rest of it. So what are the actions? What are the elements, or what are the things we should be looking out for if you want to sue someone for trademark infringement? One, is there a likelihood of confusion amongst your consumers? Like, can Coca-Cola fans and consumers confuse Pop Cola for Coca-Cola? Like, if I go into a store now and I just go to the fizzy drink line and I just pick a bottle thinking it's Coca, is it possible that I would just pick Pop Cola and think it's Coca-Cola? That's one of the tests you need to carry out and determine. Then, unauthorized use of the mark. Did the person use your trademark, be the name, logo, design, symbol, sign, whatever it is, without your consent? Was your reputation and goodwill harmed in any way? How much damage was done to your reputation and good? For instance, now Coca-Cola, that has been in Nigeria for the last 69 years, how bad has Pop Cola's action damaged Coca-Cola's business, especially in Nigeria, in Kano, which is the northern part? Would you say their action was intentional? Did they intentionally do it to divert customers from Coca-Cola? I mean, Pop Cola is like, it's said that it's a viral sensation in Kano State. So let me just reserve my comment as to whether their action was intended to divert sales from Coca-Cola. What is the commercial value of Coca-Cola as opposed to Pop Cola in Nigeria? Now, I read an article by Naira Matrix with the headline which says Coca-Cola has invested or invest 9 billion naira over the last 10 years, and they also want to inject another $1 billion in 5 years. Let's compare and contrast, okay? Let's just compare, because like, who has more commercial value at the end of the day? Next up on that conversation is, what are the rights that a registered trademark owner has in Nigeria? One, they have the exclusive right to use the mark in Nigeria as long as it's been registered. They also have the right to sue and seek statutory remedy against an infringer, as like what Coca-Cola is doing about obtaining an injunction, which is, so an injunction is like an order gotten by an IP owner or a plaintiff, or the person suing, a claimant suing the defendant from the court. So they get the order from the court to restrain the defendant from further doing any specific things or tamper with a locus or status quo or whatever. So you get that order from the court, and you stop party B from doing anything that don't do anything until we are done with this case. Now, in this case, Coca-Cola has asked the court for an interim injunction, which is basically granted before an official trial commences, and also for parties to maintain status quo in the case, pending the hearing of the suit in question. Now, a recent updates which came up on the 22nd of February, where the Federal High Court sitting in Kano State declined Coca-Cola's request for an interlocutory injunction, which was sought to stop Pop Cola's manufacturers from further conducting their business in Kano and Nigeria pending the hearing and determination of the suit in court. So Coca-Cola lost that part. They did not get the interim injunction they were hoping to get. That means that Mamuda and Beverage Nigeria would continue producing Pop Cola until the case has ended. Now, another good thing about this is that if the case is in favor of Coca-Cola, they can, I don't know if that they included that, but they can ask for account of profits, you know. But I think if you decide to sue someone for IP infringement, have a good strategy. Make sure that your your processes which you're filing in court is solid. Like, don't leave any room for anything, because expect the unexpected when it comes to litigation. Whereas for alternative dispute resolution mechanism, both parties eventually they do want something, but one person is just being a bit stubborn, like, nah, I'm not gonna do this, I'm not gonna do that, or maybe there's a breach, or just whatever. Another thing we should consider as a right is unfair competition and trademark infringement. Using this our case study now, unfair competition is said to be a means of resorting to unfair and dishonest practices to tackle rivalry, while trademark seeks to protect any trademark or distinguishing element of a business from any mock-up or knockoff or counterfeit initiated by a rival that acts as a breach of restriction or fairness in competition. Now, I did a poll on Twitter. So far, it has just 7 votes. And I said, would Pop Cola's action be considered to be an unfair competition or trademark infringement? Now, 86% says an unfair competition, while 14% said trademark infringement. So, WIPO defines unfair competition as an act contrary to honest practice in industrial and commercial matters. And under the Paris Convention, Article 10b, it states that unfair competition creates confusion, is capable of misleading the public as to the quality of the goods. So I read a few comments about the Pop Cola where people were like, oh, it's inferior to Coca-Cola, but I really don't know what makes it different that those in kind of really enjoy drinking it. The manufacturing process, etc., comparative advertising. So I think there's one of their adverts that I saw that has is you have the right to assign. You also have the right to use it as proof of validity of the original registration of your mark. I was about to hop on some TikTok trend right now, but let's move on. So, what is the difference between trademark and trade dress? So, I don't know how many of us has Googled the IPs that the IPs that Coca-Cola owns, but trade dress is one of the IPs that Coca-Cola explored. Remember, I've always said that your intellectual property can have a multi-layered IP protection. So you could have a copyright protection for your product or your service, trademark, industrial design, patent, you name it. You just have to figure out what would apply to your brand or your intellectual property. So trademark protects the distinctive name, logo, sign, symbol, you name it, that of a brand or a product or a services, while trade dress protects the elements that makes up the overall image of a product or a service. Now it could be the non-functional elements of a product, and it's not limited to color or shape or size or packaging of a product. Anything that basically just makes the presentation of a product or service distinctive is considered to be trade dress. Oh, now one interesting thing I found out in the course of this research was in a book by Isaac Oboa. Please check him out. He wrote a book called Understanding Trademark Laws in Nigeria. And he said trade dress can be registered as a trademark in Nigeria, which helps to prevent companies like Coca-Cola manufacturer from using unfair practices in their effort to compete with Coca-Cola, as the case may be. You can also sue them for trade dress. You can also sue for trade dress as passing off at the Federal High Court. So you can include in your processes which you're filing in court that you're suing for passing off of the trade dress, so the overall element of your product at the Federal High Court, which has a jurisdiction to hear intellectual property matters in Nigeria. Now, another distinction I want to talk about is the difference between trademark and trade name. We already know what trademark is, so I'll just focus on trade name. And trade name is the business name used or associated in the course of you doing trade, and also in line with the objectives of your company, which you have registered under or registered with the Corporate Affairs Commission in Nigeria, as provided for in Kama Kama run my life. Sorry guys. However, anyone that registers his trademark first enjoys a higher level of protection as opposed to someone who just does a corporate affairs, a CSU registration, say as a business name or a private limited company. Trade name is similar. So a trade name that is similar with the intention to cause confusion or deceive the public is considered to be an infringement. So see the case of the Niger chemist against Nigeria chemist. Okay, so we're wrapping up very soon, guys. I hope you've enjoyed listening to my talk. Don't forget you can consult, which I built. I had to whisper that, sorry. But yeah, guys, let me know your thoughts so far on this episode as we're wrapping up right now. Ayo. So in conclusion, these are just my recommendation and my general thoughts after all the long things I've said. So one, take note that you must use your mark for commercial purpose. Anything contrary to that, so you want to use someone else's mark, get their consent, permission, authorization, else your action or your act will be considered to be an infringement. You can enforce your trademark right by authorizing and briefing a lawyer who is specialized in intellectual property like me to do a cease and desist letter on your behalf. So a cease and desist letter telling the person to stop using your mark without your consent, give them a timeline XYZ. You can also do a public notice to the public and consumers telling them that you are not associated or affiliated with this brand that is passing off your goods, yeah. Then you can approach the courts like Coca-Cola did and sue for infringement. I'm hoping this turns out in favor of Coca-Cola, but I will still have to look at what the court's decision is once they are done. You are entitled to the following remedies under the law, be it as a civil or whether it's a civil case or a criminal case, as the case might be. You're entitled to monetary damages, you're entitled to injunction, so you can ask the court for an interim injunction restraining the other person from continue using your mark and producing and distributing your product like Coca-Cola did and lost, which is sad, Anton pillar order, or you can also get an account of profit. I know I mentioned that we're having a discussion. You can also explore the commercial element of your mark by assigning it in line with section 26 of the Trademark Act. You can oppose the registration of that person's mark if you consider it to be similar, but you have to show and prove why you're opposing it and why the elements are really similar. You can also build a franchise like Coca-Cola have done over the years in different countries. Okay, take note that in Nigeria we apply the first to file principle and not the first to use. So no be who use the mark first to, no be who use pop or who use the styled ribbon device wey go get the mark for Naija. Now who go trademark registry go register the mark, na him go get am. Okay, IP is also territorial in nature. Employ or retain an IP lawyer in your company, so it saves you from all these suits. So I see job adverts where someone is looking for a lawyer and then they include IP as one of the requirements. IP is a specific role, so you're not supposed to mix the roles of an IP lawyer with, say, a taxation work, except if the person is doing like so you're going into a merger and you have to do some sort of IP valuation. Person's an analyst, a consultant, the rest of it. Yeah, that works. But not to say, oh, I'm looking for a lawyer that does corporate affairs, does taxation, does intellectual property, does. Nah, if you're looking for an IP lawyer, please state it. I'm looking for an IP lawyer that will manage our portfolio, help us in protecting our work, XYZ, blah blah blah. What else? When choosing a mark, be it a name, logo, sign, design, symbol, etc., always go for a fanciful or coinful name. I mean, something really sexy. So for instance, I'm going to use my parents. My dad, coined the name for me when I was to start at my law firm. Then his business name as well is a combination of his name and my mom's name, which is very, very, very unique. Memda. Kudos, dad, and well done. Then take note that the economic purpose of intellectual property is to encourage investment, creativity, innovation, and also preserve standard of loyalty. I mean, Apple Inc. fans and consumers, like iPhone fans, are like very loyal. Samsung fans are very loyal. And loyalty can go a long way for certain sectors like the entertainment sector, where you need your fans to like buy your merchandise and come through for you, etc. And also aids transparency and enhance creativity and innovation, and also healthy competition. And so with that, I've come to the end of today's hashtag IP series episode. Let me know what you guys learned. Send me voice notes, guys. I look forward to hearing from you guys. Favorite my podcast, share, like, subscribe, just come through for me, guys. And I look forward to seeing you guys in my next episode. Cheers, guys. Have a fantastic day. Bye.